Hello, I'm Mark Allenbaugh, and this is sentencingstats.com. Today is Saturday, December 8, 2018, and today we'll be discussing the sentencing of Michael Cohen, or the upcoming sentencing of Michael Cohen. It's been a very busy week, very busy month for federal sentencing. On November 30th, the government, or the Michael Cohen filed his sentencing memorandum. He is requesting essentially a sentence of probation, although technically time served. He does have a few hours of credit for when he was processed in the system once he was arrested. Be that as it may, he has taken a typical tactic, or I should say his counsel has taken a typical tactic when arguing for a low sentence or a sentence well below his guidelines range. By the way, his guidelines range will be 51 to 63 months. We'll talk about that in a little bit more detail here in a minute. He cites, the typical tactic is to cite to favorable sentences. So for example, he looked at the case of Earl Simmons, also known as DMX. His guideline range was 57 to 60 months, but he only received a year in prison. Cohen also cited to the case of Lacey Doyle, who engaged in some complicated offshore tax evasion, but only received 4 years probation. And then finally, he has a series of charts or a table that lists a number of individuals that committed some pretty serious tax or ostensibly tax offenses. They were not criminally prosecuted, though. They were able to resolve their tax matters just civilly. This is as an example of possibly selective prosecution on his part. Yesterday, the government filed its sentencing memorandum, and of course, it doesn't agree with Mr. Cohen. Rather, it suggests that a sentence of around 42 months is appropriate. The probation office does agree that a modest, a 9-month downward variance should be imposed, but it doesn't say why. There's no evidence, at least cited in the sentencing memorandum, for 42 months as opposed to 41 months or 43 months. Be that as it may, the government does note that the probation's recommendation does not take into account Cohen's assistance to the special counsel's office. So reading between the lines, the government seems to be telling the judge maybe something a little less than 42 months, perhaps 40 months would be appropriate here. But the government does note that certainly a sentence of time served is 99.5% lower than even what the probation office is recommending. And the government does make a very astute observation about the problem of Cohen's counsel's tactics, which are quite common, and that is cherry picking. In support of his request for time served, Cohen cites several cases in which the defendant received little or no jail time. The cases selected by Cohen do not bear any particular factual similarity to the instant one. Indeed, in none of the cases cited by Cohen did the defendant commit the particular array of crimes that Cohen has. As set forth below, the court could just as easily identify numerous examples of cases where more substantial sentences were imposed. Thus, the cases cited by Cohen do not provide a template for sentencing in this matter, and the court must decide it based on the particular facts and circumstances of the case. Now, the government certainly is right. Cherry picking is a problem, whether you're the defendant or the government. Doesn't help the judge, and many judges have published opinions on this, that cherry-picking cases don't provide any guidance. So what they're left with isn't just the particular facts and circumstances of the case. Congress has told judges that, of course, they must take that into consideration, but they also must avoid unwarranted sentencing disparity, and that is the whole purpose of the guidelines, is to avoid unwarranted sentencing disparity, as well as to provide certainty in sentencing. But since the guidelines have been made advisory 13 years ago in the Booker case, what guidance do the guidelines provide? Very little, as it turns out. And we're going to take a look at that. But the point simply is that cherry-picking cases isn't enough, but there is something that you can look at, and that's the sentencing data. This is the one area that is often neglected when looking at the guidelines or looking at the Commission's website, for example. They do publish their sentencing data, their data files. Now, they're very sophisticated and they're very robust. Here at Sentencing Stats, we've made them very accessible to everybody. So we encourage you to take a look at our site and play around with it. Right now, it's free. the point simply is, if one was to look at the sentencing data to find out what constitutes an unwarranted sentencing disparity, a whole universe of information appears. So first, let's look at what his guidelines are. He stipulated to a guideline range or a guideline calculation along these lines, almost along these lines. He thinks that Cohen thinks that his final offense level is going to be 23. The government, the probation office, think it's 24. Pretty sure the court's going to agree with the government, the probation office, that his final offense level is 24. We don't need to discuss why he thinks it's only a 23. It's a technical issue. But at any rate, the point here, though, is once you have this number, and it doesn't really matter too much how you get there, but once you have this number, you have this range. Now you can look at everybody else that's been sentenced under this guideline that has a final offense level of 24, and in this case, criminal history 1, so they're going to have the identical sentencing range. That is the key variable for comparative purposes to determine what others who are similarly situated have received, what kinds of sentence. And now it's going to be hard if you're the defense counsel, when you present this data to the court, it's going to be very difficult for the government to rebut and say, yes, but even those cases are different. Well, every case is different. Are they different in any relevant sense? And for guidelines application purposes, they're not. Because again, once you're at a 24, it doesn't matter how you get there. You're at the same final guidelines range. Now the question becomes, is what kind of sentence do you get? Before the guidelines were made purely advisory, you'd be pretty sure, in terms of certainty, that you'd get somewhere in this range. And that was the certainty and uniformity that the guidelines were after. But now that the guidelines are advisory, as it turns out, you don't get anywhere close to this range, or most people don't. And the question now becomes, is what do you get? What is a typical sentence? And that's where we come in. Sentencing Stats provides an easy-to-use online tool for counsel and clients and judges and prosecutors even to take a look at the U.S. Sentencing Commission sentencing data. So when we take a look, I just did this statistical run this morning. What this looks at is everybody that was sentenced under 2B1.1, like Cohen, final offense level of 24, and criminal history 1, just like Cohen. Although it's not shown on here, the other thing I did is I filtered out everybody that may have been subject to a mandatory minimum sentence or a mandatory consecutive sentence, such as that would be imposed for aggravated identity theft or something like that. Since Cohen isn't subject to any of those, and I want to try to find those individuals who are most identically situated to him, I looked at, I filtered those out, those individuals out. So what I was left with was 1,391 cases that were identically situated to Cohen. Turns out, look at the average, only 37 months, and the median's only 40 months. Now, this includes everybody that received a downward departure, downward variance, within guideline sentence, and even above guideline sentence. This is the whole universe of individuals that meet this criteria and were not subject to a mandatory minimum or consecutive sentence. This is very informative if I'm a judge, because if I'm looking at this and I'm thinking, well, 42 months is quite a deal. That's 9 months below the guideline range. Well, turns out it's not really that much of a deal because that's already what people typically are getting. In other words, regardless of the government arguing for a downward variance or even the probation office, if you're trying to avoid unwarranted disparity, you're going to want to give a below guideline sentence. And you can see here in the Second Circuit and in the Southern District of New York, where Cohen's going to be sentenced, the numbers are even more favorable. So let's look at the trend. So this shows the median sentence. The median means half the people got a sentence above that amount and the other half got at that amount or below. So for example, starting in 2006, the median sentence was 51 months, which again, this was right at the cusp when the guidelines were now made advisory by the U.S. Supreme Court. And since that time, you can see they've trended downward pretty consistently. In the last couple of years, they've trended up slightly, but not much. Now, as of last fiscal year, 2017, the median is only 36 months. So that's significantly below the bottom of the guidelines range. And you can see here a 42-month sentence is in the 54.6th percentile, meaning that it's greater than 54.6% of the sentences, meaning most, the majority, received a sentence of 42 months or below. So if I'm a judge, I'm going to take a look at this and think, wow, you know what? I got to recalibrate my thinking and not look at the guidelines, because the guidelines don't tell me, the guidelines don't really provide a starting point. This is more of a reasonable empirical starting point. What this shows is the frequency of variances, and this kind of explains what has been going on as judges have been imposing downward, as we can see here, they've been imposing sentences below the guideline range with increasing frequency. And this looks at the 2006 to 2017 range as a whole. We can see that in almost a third of the cases nationwide, judges have imposed a downward variance for those who are identically situated. Those 1,391 individuals here in the District of New York, Southern District of New York, almost half the time they're getting a downward variance. And so Cohen's lucky to be in this district. It's rather generous. So yeah, he's getting a downward variance, but how much? That's the real key. And what we can see here, it's about 22 months is what the typical or the average downward variance has been. And we know he's going to get a downward variance. But this is just one number, and we can get even more information and more data out of this. So we know that the average is 22 months below. So as a judge is going to take the 51 months and subtract 22, and that's the sentence? Well, perhaps, but there are some obviously unique factors here to Cohen's case. And really what the judge wants, and as the guidelines originally recognized, is not a specific point, 36 months, 38 months, 32 months, or something like that. The judge wants a range to factor in some other variables that have not been taken into consideration by the commission in formulating the guidelines. So providing the judge with a range is much better than just a static number, because really what the number doesn't tell you, like here, is the distribution. And that's the key, and that's the key insight that we provide here at sentencingstats.com. Certainly we're going to give you the median and the average, etc., but what we can also provide is the distribution. How many sentences are at 35 months, 34 months, 33 months? Are they all grouped kind of close to here, or are they just kind of a mess all in between? Same with above. Well, we can tell. Now, we can tell you now, and that's what our box and whiskers approach shows you. This isn't available on our website, but it's something that we can do for counsel and clients, courts, etc. This is the box. These are the whiskers. This is a very typical way that statisticians use to display data that can be highly distributed. Now, what's very interesting that should occur to you quickly, or just right off the bat, is, boy, this is a big distribution for sentences that otherwise are supposed to be, for cases or defendants that otherwise are identically situated. And yes, that is true. These are big distributions, which is why you can't look at the guidelines range anymore as providing any type of reasonable insight to what a typical sentence is. A within guideline sentence is atypical now. And that is exactly what this blue box and whiskers shows you. So first off, this yellow band here, this is the actual sentencing range of 51 to 63 months. What this blue box shows you is those 1,391 individuals nationwide that match this sentencing criteria. This is the distribution of sentences that they received. Their average was 36.8 months. This is overall from 2006 through 2017. The median sentence was 40 months. The top of the box here represents the third quartile, or the 75th percentile. What that means is 3/4 of these defendants received a sentence of 51 months or less. The bottom of the box is the first quartile, meaning that 25%, quarter of them, received a sentence of 2 years or less. So half of the defendants meeting this criteria received a sentence between 51 and 24 months. These whiskers here, these do not necessarily represent the maximum and minimum. What they do is they represent thresholds. Any sentences, and there were a few above 87 months, represent outliers. They're statistical anomalies, and those really need to be taken a harder look at, because there's something very, very unusual about them. They don't fit the normal pattern of the distribution. So, for example, if the government's asking for a sentence up in this range, you can say, look, Your Honor, that's really bizarre. And there's something very unusual about that. It's certainly beyond atypical. It's an anomaly. But sentences above or below these lines are atypical. If these are anomalies, this is your zone of atypicality. Most of the offenders, or at least half, are getting sentences right in here, grouped around the average and the median. So this would be a better starting point, is my point, for courts to look at if they're trying to avoid unwarranted sentencing disparity, taking into consideration the realities of today and the advisory nature of the guidelines. But there's one factor that this doesn't take into consideration. This includes, as I said before, everybody that's been sentenced above as well as below, obviously, the guidelines range, as well as those that have been sentenced within the guidelines range, which would be this group here. We know that Cohen is going to receive a downward variance, so we want to add in that filter or that variable. But he's not going to receive a 5K. So what this represents is it's a subgroup of this. It's everybody that received a downward variance, but not a downward departure for cooperation, because we know that Cohen's not cooperating. He's partially cooperating, but he's not getting a 5K letter from the government for a formal downward departure. So just looking at those that received a downward variance, there were 422 of them. That's what the N means. 37 of them received probation. P equals 37. That's what that means. So even though Cohen is effectively requesting probation, it's very atypical. It's very unusual. He's going to have some really good reasons to argue for why probation is deserved in this case. It's not unprecedented, but again, very unusual. Less than 10% of the individuals that are otherwise identically situated received a sentence of 37 months. But just as likely, a sentence of 42 months also is atypical. It's atypically high. This zone is it provides the court with a better, if the court is interested, as it must be, as it's directed by Congress to do, to avoid unwarranted sentencing disparity, look for it. You're going to want to impose a sentence of between 20 and 40 months, at least statistically speaking, to avoid unwarranted sentencing disparity. So, and this is something that, rather than cherry-picking cases, this would be a much more empirical and really scientific way of presenting data to the court, and not just a sample. This is the whole universe of individuals that have been sentenced under 2B1.1, total offense level 24, subject to no mandatory or consecutive sentence, and sentenced between 2006 and 2017. The whole universe, and that received a downward variance. So here, this is arguably the most impactful thing that a court can consider and should consider if, again, the court is interested in, as it should be, avoiding unwarranted sentencing disparities. Somewhere between 20 and 40 months is where the sentence should lie. Now, with that said, that doesn't mean that the court is a sentence above 40 months or below 20 months wouldn't be unwarranted, given certain other factors that may not be known to the public, or even those that are known to the public. The fact that the president is involved in some of this offense conduct and he provided assistance, well, maybe more than just 2 months below the probation officer's recommendation would be appropriate. Maybe something a lot less than that, given that this is the typical range anyway. Maybe something below 20 months or a year and a day would be much more warranted in light of the assistance he provided. So be that as it may, one of the things that I did mention, finish up here, is Cohen is not getting a 5K for a downward departure for cooperating. He only partially cooperated, and if you only partially cooperate, you're not going to get a full cooperation. He provided cooperation with respect to the offenses involving Trump, but from my understanding, he did not provide cooperation with respect to the offenses that were specific to him, namely the loan fraud, the tax fraud. So he didn't get that cooperation letter. Obviously, he would have likely received an even lower sentence than the one he's already going to receive, but perhaps not much lower. You can see this big overlap here. So, frankly, if you got a sentence of 33 or the average of 29 months, that's probably what he could have received anyway by cooperating. It certainly would have been on the high side, but still within this typical range. So point being is it was a gamble for him not to fully cooperate, but it doesn't look like he's lost much. One way you can compare the two is just look at the averages. It looks like he's going to maybe do about 8 more months as a result of his failure to fully cooperate. But that's somewhat skeptical. If I'm explaining this to an attorney, I'd say it's kind of a wash, statistically speaking. So he didn't buy him. Point is, by not fully cooperating, it doesn't look like he lost much in terms of additional sentencing, an additional sentence reduction. At any rate, thank you for listening. I'm Mark Allenbaugh with SentencingStats.com. Please stay tuned for our next episode, which will involve cover the upcoming sentencing of Paul Manafort in light of the breach of his plea agreement. Thank you.